This week on the Esther Krakue Show.
Who belongs? What makes a people? Why should the location of birth on its own be enough to trigger permanent membership in a self-governing nation? It's not a modest move. It's an attempt to redraw one of the most basic membership rules in the country. Trump's challenge to birthright citizenship turned that question into an active legal battle. Critics see that as a kind of sovereignty trap. What exactly happens to the children? If you remove automatic citizenship at birth, who is inside the circle? What is birthright citizenship, and should it be abolished? Birthright citizenship is one of those ideas that sounds simple until you stare at it for 5 minutes and realize it opens up some of the deepest questions a country can ask. Who belongs? What makes a people? Is citizenship a legal status, a cultural inheritance, a political compact, or something much older and thicker than that? Can a nation really just be a set of rules open to anyone who arrives and then happens to have a child within its borders? Or does that empty citizenship of any deeper meaning altogether? That's why the argument of a birthright citizenship matters. On the surface, it looks like a fight about immigration law, but in reality, it's a fight about what a country thinks it is. It's a fight about whether nationality is primarily about place, blood, law, history, consent, or belonging. It's a fight about whether citizenship is supposed to be automatic, almost mechanical, or whether a nation has the right to guard it more jealously than that. And even though this debate has been reignited in America by Donald Trump's attempt to challenge the current understanding of birthright citizenship, the underlying question goes well beyond Trump, well beyond one administration, and well beyond one court case. Because once you start pulling on this thread, you're no longer just talking about one constitutional clause. You're talking about the very meaning of nationhood in the modern West. So let's start with the basics. Birthright citizenship usually refers to what lawyers call jus soli, the right of the soil. Under that model, you're a citizen because you were born on the territory of the country. The rival idea is jus sanguinis, which is the right of blood, where citizenship is inherited from one or both parents. Now, in reality, most countries are not pure examples of either one. Most operate a blend. Some allow citizenship by birth on the territory, but only if the parents meet certain conditions. Some rely mainly on descent, but allow children born in the country to register later. Some make exceptions to avoid statelessness. Now, this isn't a neat moral divide between good countries and bad countries. It's a set of different legal answers to the same basic question. When should a newborn child be treated as part of the nation? That matters because in American political debate, you often hear people speak as though birthright citizenship is just a normal democratic standard, and anyone questioning it must be some sort of extremist. That's not true. America's system is unusual among developed countries. It's not unknown, but it is unusual. Much of Europe, including Britain, doesn't give automatic citizenship simply because a child is born on the territory. In many countries, the parent's status, citizenship, or settled residence matters. That doesn't tell you what America should do, but it does matter because it means that this debate isn't between civilization and barbarism. It's a debate between different models of citizenship, all of which are used by states that consider themselves perfectly legitimate. America's model is rooted in the 14th Amendment. The key line is famous. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. That language was adopted after the Civil War. It was part of the Reconstruction settlement, and one of its central purposes was to overturn the logic of Dred Scott, the appalling Supreme Court decision that said Black Americans couldn't be citizens of the United States. The Civil Rights Act of 1866 had already declared that people born in the United States and not subject to any foreign power were citizens. The 14th Amendment constitutionalized that idea, so it couldn't simply be repealed by a later Congress. So in the American story, birthright citizenship isn't just an administrative rule. It's part of a historical settlement made after slavery. It was meant to settle something fundamental, that the Republic couldn't keep producing people born on its soil and then treat them as permanent outsiders. That history matters because it's one reason the issue is so politically explosive. If you support keeping birthright citizenship, you can frame it as a constitutional safeguard against hereditary exclusion. If you oppose it, you have to explain why that safeguard has been stretched too far beyond its original moral purpose. And that's exactly where the argument lives, in the phrase subject to the jurisdiction thereof. On one reading, that phrase means something broad and practical. If you're born in the United States and subject to its laws in the ordinary sense, then you are under its jurisdiction and you are a citizen, with a few narrow exceptions such as the children of foreign diplomats. That has long been the mainstream understanding. On the rival reading, jurisdiction means something more than simply being physically present and answerable to the police. It implies a fuller political allegiance. Under that view, the children of people who are in the country only temporarily or unlawfully are not really within the full jurisdiction of the United States in the constitutional sense, and therefore don't automatically qualify for citizenship. That is the legal hinge, but it's also a moral one, because behind the technical language is a bigger disagreement about what citizenship actually represents. Is it a fact that the state recognizes or a bond the state confers? Is it a human reality or a political choice? The most important Supreme Court case here is the United States v. Wong Kim Ark from 1898. Wong Kim Ark was born in San Francisco to Chinese parents who were subjects of the Emperor of China and who, because of the racial laws of that era, were not eligible for naturalization. When he returned from a trip abroad, the US government argued that he wasn't entitled to re-enter as a citizen. The Supreme Court disagreed. It held that because he had been born in the United States and because he fell within the traditional common law rule of birth on the soil, he was a citizen. That case didn't arise in the context of modern illegal immigration as we understand it now. The legal architecture was different. The politics were different. But Wong Kim Ark became the great constitutional anchor for broad birthright citizenship in the United States. It's the reason that anyone who wants to abolish or seriously narrow birthright citizenship in America faces a problem that's not merely political. It's doctrinal, it's constitutional, it's historical, and it's baked into the legal architecture. And yet the pressure against it has never fully disappeared. Because the critics aren't asking a silly question. Their basic point is this: why should the location of birth on its own be enough to trigger permanent membership in a self-governing nation? If two tourists fly into New York, stay for a week, have a baby early, and leave, why should that child automatically receive one of the most valuable citizenships on earth? If two temporary workers are in the country for a short contract, why should that change the status of their child forever? If two people have entered unlawfully, why should the state be required not merely to tolerate that fact, but to translate it into permanent political membership for the next generation? Now, you can disagree with that argument, many do, but you can't say it's obviously irrational. In fact, most of the world's states take some version of that concern seriously. And that is where the comparison with Britain becomes useful. In the UK, if you're born on or after the 1st of January 1983, you're not automatically British just because you were born on British soil. Usually, at least one parent must already be a British citizen or be settled in the UK at the time of birth. If that's not the case, there may be later routes to registration, including where the child lives in the UK for the first 10 years of its life, but the principle is different. Birth alone no longer settles the matter. Britain didn't make that change because it had suddenly become a fascist state. It made it because it decided that simple birth in the territory wasn't enough on its own to define political membership. That is a completely mainstream position in global terms. So when Americans talk about birthright citizenship, they need to be honest. If they want to defend it, they should defend it as part of America's particular constitutional and historical tradition, not as some universal law of decent societies. And if they want to attack it, they should be equally honest that they're challenging something deeply embedded in American constitutional development, not just importing a harmless little policy tweak from Europe. Now for the Trump argument. Trump's executive order on citizenship says, in essence, that the existing interpretation of the 14th Amendment is too broad. It argues that not everyone born in the United States is automatically subject to the jurisdiction of the United States in the constitutional sense. In practical terms, it seeks to deny automatic citizenship to certain children born within the United States on the immigration or residence status of their parents. Now, whatever else you think of that, it's not a modest move. It's an attempt to redraw one of the most basic membership rules in the country. What matters here is that it's not just some dusty theoretical argument dragged out for cultural war theatre. It's a live constitutional and political fight over one of the most basic questions any country can ask. Who gets to belong by default? Trump's challenge to birthright citizenship turned that question into an active legal battle, but the bigger issue goes well beyond one administration or one case. Even after the court drama fades, the underlying argument will remain: whether citizenship should be automatic, whether it should be inherited, and whether a nation has the right to draw that line more tightly than the United States has traditionally done it. The reason this debate matters is not simply because Trump raised it. It matters because it forces America to confront what citizenship is actually for. And there's serious arguments on both sides. The strongest case for birthright citizenship in America begins with clarity. A bright line rule is simple. You're born here, with a few narrow traditional exceptions, and you are a citizen. There's something powerful about that. It avoids a murky world in which a baby's status depends on a bureaucratic excavation of the parent's exact immigration category on the day of their birth. Because once you move away from a bright line rule, the state has to answer a string of messy questions. Was the mother on a temporary visa? Was the father unlawfully present? Was one parent a permanent resident? Had somebody overstayed by 2 months or 2 years? Was the paperwork pending? Was the status lawful but non-immigrant? It doesn't take much imagination to see how that can generate confusion, delay, litigation, and entire categories of children whose place in the country becomes uncertain before they can even walk. That matters for social cohesion too. One of the arguments for birthright citizenship is that it takes the second generation and incorporates it cleanly and early into the national story. A child born in America grows up being told, "You are American." The country claims you. You belong here. That can be an extraordinarily powerful assimilation mechanism. It channels loyalty inward. It makes the nation feel like home from the very beginning. If instead you tell millions of children born in the country that they're not truly of it unless the state later decides otherwise, you may get the opposite effect. You don't necessarily produce stronger borders or a more confident nation. You may simply produce a larger liminal population. American born in every social sense, but legally marked off from the polity. And then there's the constitutional point, which isn't small. The citizenship clause exists. The federal statute mirrors it. Wonky mark is still there. You can't just wave all that away because the politics have changed. If the United States wants to abolish constitutional birthright citizenship, the strongest objection from defenders is that the honest route will be a constitutional amendment, not a creative executive branch reinterpretation of settled language. That argument is about legitimacy. A constitutional republic shouldn't quietly redefine a foundational guarantee by administrative action if generations of courts, governments, and citizenships have understood it a different way. There's also a moral argument in favor of birthright citizenship that goes way beyond doctrine. America's always had a tension between ancestry and creed, and between nation and opposition. Birthright citizenship sits inside that tension and resolves it in a very American way. It says that the republic is confident enough to absorb people born under its laws without interrogating their bloodline. It says that citizenship should not depend on pedigree, and it says that the country can make Americans out of birth, upbringing, law, and civic formation rather than demanding some ancestral certificate at the nursery door. That ideal can sound naive in an age of mass migration and weak borders, but it also reflects something real about the American project. The United States has never been Germany. It's never been Hungary. It's never been a nation whose dominant self-image rested solely on ancestry. Its nationalism, when at its healthiest, has usually mixed constitutionalism, patriotism, settlement, language, culture, and aspiration in a strange but effective blend. Birthright citizenship is part of that blend. Now for the case against birthright citizenship. The first and strongest argument is sovereignty. A nation is supposed to have some control over membership, but broad jus soli can make membership feel less like a considered political bond and more like an automatic byproduct of geography. Critics say that if a state loses control of its borders, then birthright citizenship turns that failure into a permanent constitutional fact. The state fails to control entry, fails to remove unlawful entrants, fails to deter abuse, and then effectively has to naturalize the consequences through the next generation. From that perspective, broad birthright citizenship is not merely generous, it's destabilizing. It means that even if the people want a more controlled immigration system, the constitutional rules turn every enforcement failure into a future membership claim. Critics see that as a kind of sovereignty trap. Then there's the argument from consent. Citizenship is not just residence. It's not just a tax law. It's not merely being found somewhere on a map. It's membership in a self-governing people. So critics say, why should a democratic nation be forced to treat mere birth on its territory as conclusive proof of membership, regardless of whether the parents ever meaningfully joined the political community in the first place? That argument becomes more emotionally potent when people feel the border is porous, when asylum systems are overwhelmed, when trust in the state is low, and when elite rhetoric seems to reduce all concerns about national continuity to racism. One reason this issue has returned so forcefully is not just that Trump raised it, it's that many people increasingly feel their rulers have stopped treating citizenship as something precious and bounded. And now we get to the most uncomfortable part of the conversation: nationalism. That moment you start talking about whether a nation has the right to define its membership more tightly, someone will say this is just ethno-nationalism in disguise. And sometimes it is. Sometimes people really do mean race, even if they're too polite to say it outright. But not always. And pretending otherwise makes the conversation dumber than it needs to be. There's civic nationalism, which puts the emphasis on institutions, laws, constitutional loyalty, and shared political identity. There's cultural nationalism, which is more about language, norms, memory, and inherited ways of life. And then there's ethnic nationalism, where ancestry becomes central and the nation is understood as a blood-bound people. In practice, these categories overlap. Real countries are messy. Even the most civic states have cultural majorities and historical cores. So the question is not whether there's some perfectly pure civic model on one side and some monstrous ethnic model on the other. The question is whether a country can want tighter rules of citizenship without collapsing into racial essentialism. I think the honest answer is yes. A state can absolutely say that citizenship should depend on descent, long-term settlement, lawful residence, or later registration rather than immediate automaticity at birth, and still remain a perfectly legitimate modern state. Britain does that. Plenty of countries do. The mere fact that a country doesn't grant automatic jus soli doesn't make it ethno-nationalist. But America is not just any country. That is the complication. In America, the legal and moral meaning of birthright citizenship was forged in the context of slavery, emancipation, Reconstruction, and the repudiation of caste. That makes the issue heavier than it would be somewhere else. It means abolition is not just a neutral administrative redesign. It's an attack on a principle that sits very close to America's post-Civil War constitutional identity. And that doesn't end the debate necessarily, but it changes its weight. There's also a practical objection to abolishing birthright citizenship, which even some restrictionists struggle to answer cleanly. What exactly happens to the children? If you remove automatic citizenship at birth, you may not get a cleaner nation. You may get a more legally fragmented one. Depending on the parents' nationality laws, some children would inherit another citizenship. Some might have a clear claim elsewhere, but some would fall into limbo or face complex status questions. Others would grow up in the United States for years while being told they were not fully part of it. And that's not a trivial side effect. A modern state should think very carefully before creating a class of people born inside the country but not secure in their membership of it. America's defenders of birthright citizenship often return to this point because it goes to the heart of why the Reconstruction generation wanted a constitutional rule in the first place. They didn't want citizenship to be discretionary in a way that could create a domestic outsider caste. Still, if we're being honest, defenders of birthright citizenship sometimes dodge a real question. They often speak as if the moment you were born somewhere, the moral case for citizenship is self-evident. But why should that be the case? Why should the accident of geography carry such force? Why should a nation not prefer a more deliberate model based on lawful settlement, parental ties, or demonstrated connection? Those are serious questions, and in a calmer political climate, one could imagine the United States debating them without all the hysteria that we're seeing. You could honestly imagine a debate over whether the country should keep the constitutional core but crack down much harder on border control, visa compliance, and birth tourism. You could imagine narrow reforms around documentation and administration. And you could also imagine serious attention to what citizenship is meant to do in a country with mass immigration and elite-level confusion around nationhood. In fact, that's probably where most sensible people end up. They don't want hereditary exclusion. They don't want babies punished for their parents' conduct. But neither do they want a system where every border failure is sanctified by constitutional romanticism. They want a state that can both enforce borders and maintain a clear, humane citizenship regime. The tragedy is that modern politics tends to force people into stupid binaries, either open borders sentimentality or punitive legal absolutism. So should birthright citizenship be abolished in the United States? My answer is no, or at least not in the way its critics usually imagine. And the reason isn't that the question is morally forbidden. It's not. Nor is that every country must have broad jus soli. Clearly, they don't have to. The reason is that in America, birthright citizenship is too deeply entangled with constitutional text, legal precedent, historical memory, and national identity to be uprooted so casually. It's not some free-floating policy instrument that can simply be swapped out because public opinion has hardened. It's part of the post-Civil War constitutional settlement. It's embedded in statute. It's reinforced by a major Supreme Court case, and it's become part of how America narrates itself to itself. If Americans genuinely want to abolish this, the legitimate route would be to confront that honestly and pursue a constitutional amendment. That would force the country to say clearly and in the open that it no longer wants citizenship to work this way. That would be a democratic argument worth having. But trying to bulldoze through that history by executive order or clever reinterpretation of jurisdiction is a different thing. That feels less like constitutional seriousness and more like trying to smuggle a revolution through the back door. And yet, even as I say that, I think the popularity of the anti-birthright argument tells us something important. It tells us that many people no longer trust the state to control who enters, who stays, and who becomes part of the nation. It tells us that the argument over citizenship is really downstream of a broader collapse in confidence. If the border feels uncontrolled, if the asylum system feels abused, if elites seem embarrassed by national belonging in and of itself, then of course people start looking for harder and harder boundary lines further downstream. In that sense, the campaign against birthright citizenship is partly a symptom. It's a symptom of a political class that has often treated the concept of the nation as spankingly vulgar while relying on the stability of that nation all the same. Now, if you want to see how this debate mutates in the UK, you can't just talk about who gets citizenship at birth. You have to talk about what happens after someone has citizenship. Because we're starting to see a version of the ethno-nationalist versus civic nationalist argument here too, often in the most embarrassing and performative way possible, but the anxiety driving it is actually pretty straightforward. It's not about who comes into the country, it's about what people fear comes after. The fear is that you can have migrants who were not born here, who hold hostile ideologies, and who raise children here who are citizens, and then people look at the most extreme cases and ask, what would those children grow up to be? What happens when citizens of your own country openly sympathize with violence against it? What happens when someone has a British passport but sees Britain as an enemy civilization that should be confronted and reshaped? And that's where you hear the blunt question, why can't we just throw them out? Here's the legal reality. If you're a British citizen, you generally can't be deported from your own country. Citizenship gives you the right of abode. That's what it's literally there for. So a liberal state doesn't treat citizenship like a gym membership you can cancel when someone says something you hate. So what can the state do instead? First, it can prosecute. Free speech doesn't cover incitement to violence. It doesn't cover encouraging terrorism. It doesn't cover operational support for banned groups. If someone crosses the line into criminality, the law already has tools. Second, for the most serious national security cases, the UK has a separate and very controversial power. The Home Secretary can deprive someone of British citizenship under Section 40 of the British Nationality Act of 1981 if it is conducive to the public good, usually in national security and terrorism context. But this isn't a simple throw them out button. That power is most straightforward when the person is a dual national, meaning they have another citizenship to fall back on. If removing British citizenship would make someone stateless, the law becomes far more contested and tightly bounded, and it's exactly why the country has spent years arguing over high-profile cases in this space. The Shamima Begum saga in particular has become a symbolic case study for the whole dilemma. What can the state do to someone who joined an enemy organization, and how far can the government go in using deprivation as a national security tool? And here's the free speech tension at the core of this point. People want two things at once. They want citizenship to be meaningful and loyal, and they want speech to be free even when it's repulsive. In practice, you don't get both perfectly. You draw a line. Liberal states draw it at incitement, violence, and concrete support for terror, not at opinions I find disgusting. Because the moment your throw them out logic becomes throw them out for speech, you're no longer defending liberal democracy. You're building a country that punishes political expression by exile. So the British version of this debate ends up functioning like a warning label for the American one, because it shows what happens once you expand the circle of citizenship in a way that's hard to reverse. You may think the real fight is how do we stop people becoming citizens? Sooner or later, the fight becomes, what do we do with citizens who hate us? And unless you want exile for speech, which isn't compatible with liberal democracy, the answer has to be enforcement of criminal law, intelligence work, and a serious approach to integration that actually means something, not a pathetic oscillation between naive permissiveness and punitive overreach. So there's a balance here to strike. A country has every right to defend its membership rules. It has every right to say that citizenship means something. It has every right to distinguish between presence and belonging. But it also has a duty not to create legal categories that fracture social reality beyond repair. That's why the cleanest defense of birthright citizenship in America is not a sentimental one. It's not everyone from everywhere, or borders are bad, or nationality is just paperwork anyway. Those are weak arguments, and people can smell their weakness. The strongest defense is harder and more serious than that. It's that America made a constitutional choice after the Civil War to define the political community in a way that would not permit a hereditary domestic underclass, and that undoing that choice now would be legally convulsive, morally weighty, and institutionally destabilizing. The strongest argument against birthright citizenship is also serious. It's that citizenship should reflect real membership in a self-governing nation and shouldn't be conferred automatically regardless of the parent's relationship to that nation. But in the American sense, it runs into too many constitutional and historical walls. Which brings us back to the core question. What is citizenship for? Is it to recognize the human reality that a child born and raised within the country will usually become part of it and therefore should be incorporated from the start? Or is it to preserve the sovereignty of a political community to decide for itself more tightly and more deliberately who is inside the circle? There's no way around the fact that these are competing goods. Inclusion on one side, control on the other. Equality on one side, consent on the other. Inheritance on one side, choice on the other. Countries answer that balance differently because their histories are different. Their founding myths are different. Their experiences of migration are different. Their constitutional orders are different. The American answer for a long time has been unusually expansive. It said, if you're born here under our laws and not within a narrow recognized exception, then you are one of us. That answer was not an accident. It was forged in the aftermath of slavery and defended by the courts in one of the most important citizenship cases in American history. Whether that answer remains wise in an age of mass migration is a very fair question. Whether America should better police its borders and stop pretending citizenship rules can compensate for enforcement failures is also a very fair question. Whether other countries are entitled to use more conditional systems without being smeared as morally suspect is again a fair question. But if the question is whether America should abolish birthright citizenship, then my answer is still no. Not because the concept is sacred in every society, and not because no one is allowed to question it, because in the United States it's too deeply written into the constitutional order and too bound up with the repudiation of caste to be casually thrown out. And perhaps that's the real lesson here. Birthright citizenship is not just an immigration issue, it's a mirror. It shows whether a country thinks of itself mainly as an inheritance or an agreement, or as a historical people, or as a constitutional creed, or as a family line or a political proposition. Most countries are some mixture of both. America is too. The argument is over where the emphasis actually falls. So when people ask, what is birthright citizenship and should it be abolished? The answer is only the beginning. The deeper answer is that this is really a question about whether a nation can still say, with confidence and without embarrassment, what citizenship is supposed to be.